3 points of focus as part of our submission before you today. The City of Mariposa Parks Bylaw 301-2020 does not infringe Section 15.1 of the Canadian Charter of Rights and Freedoms. At this stage in our argument, we will focus on the distinction of homelessness. It is neither immutable nor enumerated in Section 15.1 of the Charter. The City of Mariposa bylaw meets the test of equality in Whittier v. Canada. The bylaw is not unconstitutional under Section 15.1 as it does not disadvantage based on homelessness. In fact, the bylaw is neutral. 2. The Parks Bylaw 301-2020 does not infringe Section 7 of the Charter in regard to Ms. Tillman guaranteed the right to life, liberty, and security of the person. These protected interests are not infringed upon by the city's imposed bylaw. Her ability to move freely and make choices independently have not been altered, and while she's experiencing a stressor that is extraordinary, it is not imposed by the city's bylaw. 3. The limitations on Ms. Tillman's rights under Sections 7 and 15 of the Charter have satisfied the Oakes test and are saved by Section 1. The bylaw is in the best interest of all parties and will have far more positive impacts than negative. The purpose of this bylaw is not only to further support those experiencing precarious housing situations, but also to ensure the well-being of the general public. Thank you. I will now begin with my response to question 1 about Section 15.1 of the Charter. May I begin?
Yes, please.
In regards to the first issue, and in which we state that the Mariposa Parks Bylaw 301-2020 does not infringe Section 15.1 of the Canadian Charter, let's first review the focus of Section 15.1. It is in place to prevent governments from making distinctions based on enumerated or analogous grounds that have the effect of perpetuating disadvantage or prejudice or imposing disadvantage on the basis of stereotyping. Section 15.1 specifies that every individual is equal before and under the law and has the right to the equal protection and equal benefit of the law without discrimination. And in particular, without discrimination based on race, national or ethnic origin, color, religion, sex, age, or mental or physical disability. The respondents claim that her current state of homelessness should be recognized as an analogous grounds of distinction has no basis. It is not analogous ground as enshrined in the Charter. Allow me to clarify this. The issue involves the inability to understand the parameters and define who would be in such an analogous group. Justice Ledger spoke to the inability to define this in Tandujaja v. Canada. There is no common characteristic that defines this group. Thereby, it is not analogous. It is a heterogeneous group. Further, many people move in and out of homelessness over time. It is not an immutable personal characteristic that can be protected under Section 15. It is not fundamental to a person's identity. Homelessness is a difficult and multifaceted issue that requires governmental and societal attention. However, it is not a characteristic that cannot be changed. The two-step process to test Section 15 established in Whittier v. Canada asks if the law creates a distinction based on analogous or enumerated grounds, and indeed, the Parks Bylaw does not. Homelessness is not—
Ms. Brindley, before you move off of analogous ground and into the Section 15 analysis, is it the respondents have offered submissions talking about how homelessness is a disadvantaged group. And if an immutable ground, or if an analogous ground is about a characteristic that is based on stereotype and the state continues to perpetuate that stereotype by attributing certain characteristics to them, like aside from the heterogeneous group that it is, like what about it being a disadvantaged group and that the state is attaching stereotype to it? What do you say to that?
Well, I would disagree, and I would say that enforcing a bylaw to protect the greater public, including those disadvantaged by homelessness, is not the state enforcing any type of stereotyping upon these people. They have offered many supports to the homeless, including safe housing and alternatives to living in the park. And therefore, I would say that they are not perpetuating any stereotype as they are actually attempting to help them and help the disadvantaged group. Thank you. May I
Thank
continue?
you.
Okay. The two-step process to text Section 15, established Whittier v. Canada, asks if the law creates a distinction based on analogous or enumerated grounds, and indeed the Parks Bylaw does not. Homelessness is not a distinction that is analogous, and the bylaw does not draw a distinction based on homelessness. The second question asked to satisfy Section 15 is that of whether the distinction is discriminatory, and there is a lack of distinction in the bylaw. There is not discrimination. The bylaw contains no particular characteristics in order to be enacted. The City of Mariposa Parks Bylaw 301/2020 is neutral in that no one is allowed to live in a park, and the bylaw itself does not reinforce any pre-existing disadvantages. Thank you. My colleague Shaquana Joseph Cupid will now address Section 7 of the Charter.
Good morning, Justices. May I begin?
Yes, please.
So in regards to issue 2 and regarding the respondent's claim, we submit that the bylaw 301/2020, aka the bylaw, does not deprive the respondent of their rights guaranteed under Section 7 of the Charter of Rights and Freedoms. And Canada Attorney General of B. Bradford establishes that Section 7 infringement requires a two-step analysis. At the first stage asks whether there has been an infringement of one of those protected interests, being the right to life, liberty, and security of the person. While the second stage asks whether there has been a deprivation in accordance with the principles of fundamental justice. At the first stage, we submit that the respondent's protected interests have not been compromised. With regard to the interest of liberty, the respondent's ability to both move freely and make independent choices has not been altered. Ms. Tillman has the ability to reside wherever she feels. She is not required to live in the alternative housing provided by the city. However, Ms. Tillman's only inability in this circumstance is being able to reside in a public park for an extended period of time. In regards to the aspect of security of the person, the state's actions that are imposed, or the state may, and like we must analyze whether the state's actions impose a serious psychological interference. And we submit that the current stress that Ms. Tillman is facing is greater than the ordinary stress presented in daily life, although the stress she's experiencing is a result of having to combat homelessness or precarious housing. We recognize what the respondent's experiences had led her to feel with city-provided housing. However, once again, as a public park is not considered a suitable location for individuals to reside in for an extended period of time. At the second stage, we submit that there has not...
Ms. Joseph Cupid, if I could interrupt for a second before you move to that step.
For sure.
The respondents have said that one of the infringements of security of the person for their client is the fact that she will not be able to live in a place that's close to all the social connections that she has formed, and that's going to cause serious psychological stress. What do you say to that?
Again, like as we are empathetic to Ms. Tillman's or the respondent's situation, once again, living in a public park is not a suitable location for an individual to live. And throughout the world and throughout life, you're able to make other social connections. And I feel like she'll create stronger social connections if she's living in a place that is suitable, that has, running water and, the ability for, if issues do happen and she is feeling unsafe, she's able to address that with someone who is in charge. Whereas if she is living in a public park and there is something going on, that's not really something that's able to be addressed. And while again, once we are acknowledging that she does create strong social connections in where she's living, we do believe that if she's living in somewhere that is suitable for her and she can get the help that she needs, she can create stronger connections there as well. May I continue? Thank you. At the second stage, we submit that there has not been a deprivation in accordance with the principles of fundamental justice. The purpose of the bylaw is not only to protect and support those experiencing homelessness, but it's also to ensure the safety of the general public. There are some serious public health concerns at these encampments, such as lack of water, biohazardous concerns, and just general unsanitary living conditions. By removing individuals from these encampments and giving them an option for more suitable living conditions, this addresses the original issue the bylaw was created to solve. Thank you. And now my colleague, Ms. Hume-Beardall, will respond to the third issue.
Good morning, Justices. May I begin? We submit that concerning the third issue, Ms. Tillman's rights under Section 7 and 15 were not infringed by the bylaw and will be saved by Section 1 of the Charter. To determine whether the limitations prescribed by the bylaw are reasonable, the Oakes test must be referenced and analyzed in relation to this case. Firstly, it must be decided whether the goal of the bylaw is pressing and substantial. Jalen Martin, sorry, I'm feeling so dizzy. 1 sec. Sorry about that. Actually, do you think one of my counsel could maybe read my section? I'm like blacking out a bit.
Whatever you need.
Yeah, Shaquana, could you read my section?
For sure. So good morning, Your Honors. I'll just start from the beginning. Ms. Tillman's rights under Section 7 and 15 were not infringed upon by the bylaw and can also be saved under Section 1 of the Charter.
I'm sorry to interrupt.
Yeah.
I just want to make sure. I'm wondering if we should take a little break just to make sure that everybody's okay. Does she have somebody there with her that can bring her water or anything?
Yeah, I have my parents. I'm just really sick, so the speaking is a little harder for me.
Okay. Would you like us to take a little break, or what do you think?
No, it's okay. It's okay. We can continue. I'm fine. I just don't think I can present my section.
Okay, that's fine. Do what you need to do. Thanks very much.
May I continue with the third issue?
You may.
So to determine whether the limitations prescribed by the bylaw are reasonable, the Oakes test must be referenced in order to analyze the relation to this case. So for the first part, we'll be analyzing whether the need of this bylaw is pressing and substantial. So the bylaw was created to ensure the safety of the people living in the encampment as well as the residents of Mariposa living nearby. The interest of everyone in the city of Mariposa must be the primary objective. There have been 121 complaints concerning the use of drugs used in the public park between the dates of June 1st and July 31st, 2020, compared to the same time in 2019 where the city only received 40. Now we're going to be analyzing whether the bylaw is directly proportional to its objective. So the limitations of the charter must be rationally connected to the purpose of the bylaw. The bylaw limits the rights of people, the ability for people to live in a public park while ensuring those who are living in the public park are relocated to a shelter where there's no risk of extreme cold or truck use. Once again, ensuring that they're living in suitable conditions. And then in terms, and then finally, that we're going to be talking about the positive effects of the bylaw. So the positive effects of the bylaw must be proportionate to its effects. It is evident that the remaining encampments or allowing people to live in a public park will do more harm for the parties than relocating them into safer shelters. Furthermore, the city has invested millions of dollars into adopting safer practices for individuals to be able to live in suitable housing conditions as opposed to having them living in public parking encampments. All the sections of the Oak test have been satisfied and therefore the limitations are saved under Section 1. It is neither fair nor within the best interest of all the city of Mariposa to allow the encampments as they have increased health and safety risks such as COVID-19 outbreaks and increased drug use. To continue to limit the public's access to a safe park, there are better alternatives than allowing people to live in public encampments. Thank you.
All right, does that complete the appellant's submissions?
Yes, that does.
Thank you. All right, then we'll call on the respondents.
So good morning, Justices. My name is Maya Hagen-Rattan, and along with my co-counsels Tiana Tsoukalas and Annette So, I represent the respondent in this matter. We ask that you dismiss this appeal, for there have been multiple infringements of the rights of Jade Tillman, the respondent, guaranteed to her by the Canadian Charter of Rights and Freedoms. I will begin by showing you that the bylaw infringes upon Ms. Tillman's equality rights on the analogous ground of homelessness, which is protected under Section 15(1) of the Charter. Then my co-counsel Tiana will explain that the bylaw is harmful as it strips the right to liberty and security of the person of the encampment residents, and it does not occur in accordance with the principles of fundamental justice. And then finally, my co-counsel Annette will show that the aforementioned infringements are not justified under Section 1 of the Charter. With our arguments to follow, we wish to show that oftentimes, despite the government believing that they're improving the lives of a disadvantaged population, without hearing the genuine concerns of said population, they cannot adequately make a difference and can in fact disadvantage the group further. We also wish to demonstrate the importance of ensuring that an already vulnerable population is not put in greater danger when considering the safety of the general public. Justices, if I may, I will proceed with our arguments on the first issue. So we firstly submit that Ms. Tillman's rights to equality, guaranteed to her by Section 15(1) of the Charter, have been violated by the bylaw after analysis with the Kapp-Whitler test. The first step of this test requires that we identify a distinction caused by the bylaw on the basis of an analogous ground to those enumerated in Section 15(1). So in order to determine whether a ground is analogous, we must determine that it is either immutable or constructively immutable. And we acknowledge that homelessness is a trait that can be changed, and as such, it is not immutable. But we do submit that it is constructively immutable. This designation typically is defined in close connection to personal identity, but we wish to argue that not all previously determined analogous grounds are necessarily related to identity, citizenship as an example. And as such, constructive immutability refers rather to something extremely difficult to change. And we submit that homelessness does fit within this category. Now, homelessness has been found to not be an analogous ground in the past, as brought up by the appellant, notably in a case called Tenujaya v. Canada. Their argument was based on the idea that homelessness is both indefinable, meaning that it lacks clear parameters for identifying its members, and that it is heterogeneous, meaning that it has diverse membership rather than being representative of discrete and insular minorities, which is what Section 15 is said to pick out. It has, however, been articulated by Joshua Seeley Harrington of Toronto Metropolitan University and elaborated upon in our factum that these arguments are not sufficient to deem homelessness not an analogous ground, as many of the traits that Tenujaya argues analogous grounds must have aren't actually traits that the enumerated grounds have. But whether the arguments put forward in Tenujaya are valid or not, we submit that their findings are not actually relevant to the case at hand, as their definition of homelessness is considerably more broad than the definition in this case, namely those without homes. And the dismissal of the findings of Tenujaya on this basis has been done before, one example being in Black et al. V. Toronto. So as homelessness has been proven to be an analogous ground, does the bylaw create a distinction on its basis? Creating a distinction is defined as either withholding a benefit.
Ms. Hagen-Rattan, how is homelessness different than residency, let's say in Northern Ontario versus in Toronto? Is residency in Northern Ontario also analogous ground based on your argument as to why homelessness should be an analogous ground?
I think that it must depend upon the situation. I'm not really sure. I haven't looked into it in great detail. I think in this case, what's most relevant is then the second step of the Kapp-Whitler test, seeing as there is like the homeless are a disadvantaged population and like they experience things that other groups may not experience that can act to diminish their living experiences. And so I don't know if that could be said for people living in Northern Ontario. Maybe it could, but yeah, that's an interesting question, and I'm not totally sure how I would answer that.
Thank you.
So creating a distinction is defined as withholding a benefit or imposing a burden on the claimant group that's not imposed on others. And we submit that uprooting individuals, forcing them to leave their communities, support systems, and potential places of employment or education is a burden that the bylaw imposes on the respondent, based on the fact that she's a homeless person living in an encampment. So the second step of the Kapp-Whitler test requires that we find this distinction to be discriminatory. And in order to make this judgment, it must be proven that the distinction perpetuates disadvantage and stereotype on the claimant group. Stereotypes about laziness, violence, drug addiction surround the homeless and are much of why the bylaw came to exist in the first place. By acting on the stereotype-based fears of those residing near the park, the government accepts these stereotypes as true. And with respect to disadvantage, the homeless are a historically disadvantaged group, specifically regarding their continually subpar access to sufficient healthcare services. By forcing these individuals to live in shelters with many others, often not following the recommended COVID-19 protocols, they are put at a higher risk of developing sickness and disease, and their disadvantage at the hands of the healthcare system becomes even more dangerous. In addition, the homeless are already less likely to be hired, and the bylaw's removal of easy access to their places of employment could easily exacerbate this disadvantage. So, as the bylaw satisfies the requirements of the Cap-Whitler test, it is thus an infringement of Ms. Tillman's Section 15 charter rights. And Justices, if you don't have any more questions, I will allow my colleague Tiana to continue with Section 7.
Thank you very much.
Okay, Justices, may I proceed? Thank you. We next submit that the bylaw is infringing upon the liberty and security of the person, which is guaranteed under Section 7 of the Charter. This infringement has been found after the Section 7 analysis. The first step of the analysis is to determine whether or not there has been an infringement to a person's life, liberty, or security. After declaring that there has been an infringement, we must determine if it is in accordance with the principles of fundamental justice. We find that the bylaw infringes on both the right to liberty and the right to security. To determine if this bylaw infringes upon the liberty of a person, we must first determine what it means to have one's right to liberty stripped away. A person's right to liberty guarantees and protects their personal autonomy. It also gives them the right to make choices in matters of their own personal significance. Based on this right to liberty that is secured under Section 7, Ms. Tillman and other residents of the encampment are entitled to choose where they reside and make a safe home. We can clearly see that the bylaw strips away this right to Ms. Tillman's liberty. Next, we will determine if there was also an infringement to the security of Ms. Tillman and other residents of the encampment. When referring to the security of a person, we are addressing the physical and mental bodily integrity of a person. The security of a person gives them the opportunity to make their own choices about their own body. We also find that the right to security includes an individual having safe as well as secure shelter. Individuals should have the right to choose where they live in an environment that fits their variation of safety. This bylaw strips away the security that was created by the sense of community in the encampments. The enforced bylaw leaves the residents of the encampment with no other option but to move into an environment in which they deem unsafe, therefore threatening their safety. Forcing the residents of the encampment out of the...
Nicholas?
Yes.
On that, for security of the person, I take it then that you're saying that the state or a government must provide housing to people, otherwise it's a violation of security of the person?
Well, it has to be, sorry, could you repeat the question?
Does the state have to provide housing to people? And if it doesn't, does that breach security of the person?
That's not necessarily what the argument's saying. Basically, they have to be able to live in a place that they deem safe, such as the encampments, that fits their version of safety, because not all of the government provided housing fits the standard of safety created by the individual or security. May I proceed?
Thank you.
Forcing the residents of the encampments out of the bounds of their safety infringes upon their right to security. Based on these findings, it is clear that the bylaw imposed violates Ms. Tillman's right to liberty and security. To state that there is a violation to Section 7, we must now find the infringement to be contrary to the principles of fundamental justice. We submit that the infringement is both overbroad and arbitrary, and therefore is in a fashion not in accordance with the aforementioned principles of fundamental justice. We find the infringement to be arbitrary because of the purpose in which the bylaw was set in place. There were found to be complaints concerning increased noise and threats around the park in which the encampment is located. This complaint is found to be arbitrary because there's no clear link between the encampment and all complaints that were submitted to the city. We also deem this bylaw to be overly broad. The parameters of the bylaw group together the entirety of the homeless population based on the possible behavior of the minority. The enforcement of this bylaw categorizes all homeless people as the same despite their behavior. Those who do abide by the rules and regulations of the park must get punished for the behaviors of others. There are other approaches that the city might take to keep the park safe, clean, and enjoyable, yet they created this bylaw which took the route of penalizing the majority for the behaviors of others because they are categorized as a collective rather than individual people. With this bylaw stripping away individuals' right to liberty and security in a manner that is not in accordance with the principles of fundamental justice, it is clearly outlined that there has been an infringement of the Section 7 rights of any residents of the snowshoe encampment park. I would like to pass the mic to my co-counsel, Annette.
Thank you.
Okay, bear with me. I'm trying to sort the screen out. Is it this?
Yeah.
Okay, perfect. All right. As we have established that the bylaw violates Ms. Tillman's section 15 and 7 rights, we now turn to the Oakes test to determine whether the infringements are justified under section 1. Now, it is said that the bylaw was passed to address 1, the concern raised by residents living in proximity to encampments, and 2, to protect the safety of individuals living in encampments. So is the objective of the bylaw pressing and substantial? Yes, and we agree with the appellant that generally speaking, public health and safety are indeed pressing and substantial objectives. But whether the bylaw appropriately addresses these objectives is a different matter entirely. So what I will do is analyze each of the objectives separately in the next section of the Oakes test. So first, is there a rational connection between the bylaw and the first objective, the safety of the residents around the encampments? We submit that there is no rational connection. The fear of the residents around the encampments is one that is based on assumptions of homeless individuals, not on evidence that the criminal behavior in parks is caused by encampment residents, as my co-counsel Maya has previously discussed. What the bylaw actually accomplishes is just to prevent residents around the encampments from seeing homeless individuals. Now, is there a rational connection between the bylaw and the second objective, the safety of the—
So before you move on, what do you say to the evidence from the police of the increase in crime within the park and around the park, the exponential increase in crime during this period?
The increase in crime doesn't, from the evidence we've been given, doesn't account for just the increase of the amount of people who are using the parks at this time. And yes, it could be the homeless individuals, but it could also be, as there's a pandemic, we have a lot more people, I guess, hanging out in parks. So the evidence doesn't account for that. And so I don't think we can say for sure that the criminal behavior in parks is caused by the encampment residents and by the encampment residents only. So to my second objective, is there a rational connection between the safety and between the bylaw and the safety and the encampment residents? Again, we submit that there is no rational connection, as staying in shelters doesn't guarantee the safety of the encampment residents. And while the city is concerned about crime and sex trafficking and open drug use in encampments, such situations occur even with supervision at shelters. Next, does the bylaw minimally impair Ms. Tillman's rights? What is important in this section is that the city must provide evidence to explain why a less intrusive and equally effective measure was not taken. The onus is on them. But there is no evidence whatsoever that any alternatives were considered, despite the many that were available. Finally, is there proportionality between the deleterious and the salutary effects of the bylaw? The city argues that the residents of Mariposa may feel more comfortable around the park and that living in shelters provides certain resources that might not have been so readily accessible in the encampments. However, we submit that the negative effects of the bylaw far outweigh the alleged positive effects. And so I will go through some of the key deleterious effects, all of which are very much interconnected and have a profound impact on homeless individuals. And to help you get a sense of just how profound those effects are on the homeless population, I invite you to put yourselves in their shoes. So imagine that you are already at a disadvantage compared to others who are not homeless. You lack resources and the finances to be able to provide for yourself and to take care of yourself or your loved ones. You can't get a job because potential employers see you as lazy or dirty or as a drug addict, all of which is untrue. And now, because of the bylaw, you are forced to move to a shelter that is completely foreign to you, far away from your friends and social workers. You lose those critical connections that would have supported you and otherwise enabled you to take the steps you need to support your economic and social mobility. You're also put in a more vulnerable position at shelters, experiencing a greater risk of danger because of violence and assault, theft, and drug abuse there. And if you're a woman or part of the LGBTQ2S community, it's even more dangerous for you as you are often targets of violence through sexual assault and hate crime. What's more is that you are already predisposed to experiencing severe symptomology or worse health outcomes of COVID-19. And so living in shelters actually puts you at greater health risk of contracting the virus. And if you do get sick, you risk spreading the virus to your neighbors, to your friends, your family, and their friends and their families and coworkers, and many others in the city of Mariposa and even beyond. So based on our assessment, none of these infringements meet the standard in the Oakes test and thus are not saved by Section 1 of the Charter. Thank you.
Thank you very much, Council. I believe that completes your submissions for the respondents.
Yes, it does.
Thank you. So I guess the panel will retire.
One moment, I'll move our panel into our judges' chambers. And actually, I think you can all just press join to go back to room 1.
It hasn't popped up on our screen yet.
Perhaps if you see a button at the bottom called More.
Okay, I see where it says breakout rooms. Click on breakout rooms and then it pops up join breakout room number 1.
Yeah, you can do that too. Yeah, that works.
Thank you.
So, Bryn, one of our students got a breakout room invitation. Should we go into a breakout room as well?
I think you can just stay here unless you'd like to, because I just don't know when our judges will be finished. So as soon as they return, we'll get going again. So don't click join.
Okay, thank you.
No problem. But if you all need a drink of water or something to eat, go for it. But just keep an eye on your screens because our judges could be back in a couple minutes here.
Okay, thank you, Bryn.
No problem. Hi, everybody. Wondering if you can make your way back to your screens. And I'm going to close the breakout rooms. So everybody should be coming back, and we'll have our judges re-entering the room. Here we are. I think everybody's back. So over to you, Your Honors.
Well, first of all, thanks very much, everyone, for your participation in this. We were all very happy to participate in this with you. It was great. It was inspiring. And I have to say, it is absolutely, and I mean this, it's nothing I could have done when I was you, which you can't imagine now since that would have been so long ago. But when I was you, I was very shy, and I would have found it very, very difficult to speak in front of a panel of lawyers or judges or anything like that. And you all just did so well in that regard. So I take my hat off to you, and the panel does as well, I know. Now, you had a problem here. When I saw this, I thought, gee, that's a very difficult problem. You know, not all of constitutional law is like this. I once taught constitutional law. And I can tell you that conceptually, sections 7 and 15 are just about the hardest thing in the charter. And again, you don't have to take my word for it. You can, if you've read some of these, and I know you've read these Supreme Court cases, the truth is that every few years, the Supreme Court sort of changes its mind on how to do section 15 analysis because it wasn't working well. These aren't the commands of the charter. Everybody thinks they're good things, and everybody agrees that they're good ideals, but they're not self-executing. They require a lot of judgment. And so the judgment, it plays out in the way the court describes the law and establishes all these tests that you folks went through. And every few years they revise and they tweak those tests to try to make them a little easier to understand, but they're really difficult. And then I haven't even mentioned the section 1 analysis. Section 1 analysis is controversial because reasonable people acting in good faith, reasonable people, well-informed people who have read all the cases disagree on how section 1 applies in particular cases. This isn't like mathematics where if you're clever enough, everybody should reach the same answer. You know, this is normative thinking. So what I mean by that is, it is often people are talking about how the law should be, how it ought to be, whether something ought to be considered a reasonable limit. And again, that's not an outcome that's provable. Reasonable people are going to disagree about that. So putting all of that together, sections 7, 15, and 1, that's a really difficult moot. And I'm proud of you all. You acquitted yourself really well. You've worked hard. So congratulations, everybody. Now, my colleagues from the court are going to give some individual feedback.
Should we just go in order of who went, Courtney?
Sure, that makes sense.
Okay, do you want to start?
Sure. So, Margot, well done, really well done, good pace. You're very organized in your submissions, so it's very, very easy to follow. And I was able to take notes to get a sense of where your submissions were going. So well done at such an early stage in your career to be able to structure submissions that way. Takes a lot of thought. I appreciated that as a judge. I knew where you were going with your argument. So just a fantastic job. I thought you were great.
Thank you very much.
Yeah, I agree with what Courtney said. I wrote down the same things. And I also wrote down that Courtney asked you a difficult question. You gave a really strong answer. You had a lot of support for it. And that was great. Good thinking on your feet. Not always easy, even for very experienced lawyers to do that. So yeah, great job.
Thank you.
Shaquana, you gave a great answer to my question. one thing that struck me about you as you delivered your submissions is just how confident and comfortable you seem to be. I don't know if you felt that way, but that is certainly the way that you come across. So I found you so easy to listen to, so easy to follow, but just your confidence inspired my confidence in your argument. So well done.
Once again, Courtney stole my points. But and you gave good answers to the questions, but also in addition to the answers being good, you didn't get knocked off track by the question. You answered it, and then you were able to go right back into what you were saying, which again is something that I think everyone from the court has seen a lot of actual lawyers not be able to do that. So well done.
Riviera, you don't have to come on screen or anything. I'm so sorry that you're not feeling well, and I'm sorry that you weren't able to do your moot, but I've been in your shoes in a courtroom where I did not feel well and I had to hand off my submissions to my co-counsel, and that's exactly what you needed to do. So well done, good judgment in the heat of a moment when you felt ill, and thank you so much, Shaquana, for stepping in and handling Riviera's submissions. Riviera, if you wrote those submissions, well done, very well structured. And Shaquana, way to hustle under pressure when it's handed over to you. So good job as a team.
Yeah, that's exactly right.
Thank you, and thank you, Shaquana, for taking over my section.
So we'll go to the second team, so the respondents. Maya, that was a great answer to my question. It showed your ability to think on your feet. It was a tough question, and it is okay to say, I don't know the answer to that, or that depends. And the best thing you said was actually that really depends on the circumstances of that case. So it was a really sophisticated answer. I don't know if you appreciate that, but well done. You have great confidence, you're well-spoken. The only one thing, just a little too fast. So make sure you take your time and maybe just write slow on every page, something that I used to have to do, and in fact still have to do. So, but just a terrific job, like a great advocate.
Once again, I fully concur with my colleague, Justice Harris. It's hard to be the opener for a side, and because you're sort of setting the stage for everyone else, right? And I thought you did a really good job of giving us a theme, not just sort of the mechanics of how the law works and just going right into, well, here's the test and here's the parts, but you had a great theme that tied your whole team together, which was, you know, the government may have good intentions, but they're not listening to the people they're ostensibly trying to help. And so even to a judge who might have gone into a hearing thinking, I don't know, I don't understand why these people are complaining, the government's doing their best, they would sit back and go, oh, well, maybe their intentions don't really matter if they're not actually listening to the people. So that really stuck with me. I thought that was great. And yeah, great answer to a very difficult question.
Tiana, you did a fantastic job as well. I don't know if you felt confident, but you seemed confident. It was really expert the way you asked me to repeat my question. And it's hard to do that when you're facing off against a judge and the judge says something and you immediately, you're like, oh, I'm so stupid. I don't even understand their question. And what you need to do is have the confidence in that moment to think, I just need to hear that question again, or could you repeat your question? So that was excellent. Keep that up in mooting and keep that up when you're in the courtroom. It does not hurt to get the judge to rephrase their question or to repeat it. So that's a really good technique. You're a little fast as well. And I think and I should have said this to Maya, one of the things I think is that you guys were packing a lot into your submissions, and it's because your analysis was actually quite sophisticated, and you've already heard Justice Hescroft tell you how difficult it is to work with Section 15 and Section 7. So Tiana, your your submissions on section 7, although a little fast, they were crystal clear, and that's a tough section to set out. So it was very much like, here's the 2 steps of the test, and here's, we're going to talk about liberty, we're going to talk about security of the person, and then I'm going to go to the principles of fundamental justice. It was very clear, so well done.
Yeah, there's a lot to pack in section 7, and I didn't have any problems following when we were at liberty and when we were at security of the person. So that was great. And again, Courtney is a tough question asker, and you gave a really good answer to the question about, you know, where is she supposed to live and what they have to be somewhere that they deem safe. And if we had more time if there was more time, I probably would have peppered all of you with more questions, but the ones that you did get, you all did a great job. And you as well, Tiana.
Thank you.
So Annette, you have a great pace, and your submissions are very compelling the way that you deliver them. You gave an excellent answer to my question, and handled it expertly. So the only one tip I thought was, and I think you were just kind of minding the clock, but when you got to minimal impairment, when you do that section 1 analysis, it's actually important to hit everything. So just on the minimal impairment, you had a couple of great examples in your factum, just to stick those in if possible. But other than that, like, just such a great job. It was really well done.
Once again, I agree. And I really liked how you put the emphasis on the onus that was on the government. It's easy when people are in the middle of a hearing to forget we're looking at the equities and who we think is right. And so to remind us, no, the onus is on them. They have to prove it. It put me back, and I thought, oh, right, yeah, that's not what. Where's their evidence? And then I think I was about to ask you a question. Well, where's the evidence? And you said, no, the onus is on them. I better not ask that question. She doesn't have the onus to prove anything. And there was some, we talked about this when we were in our retiring room. We really liked that you asked us to put ourselves in the claimant's shoes. It's not something you would normally see done, but it was very unique, and it was, I think, quite effective. And yeah, we really like that.
Thank you.
Okay, I think that wraps it up for us. So now, Bryn, are you going to introduce the award?
Yes, thank you very much. And I just want to say one more comment from OJEN's perspective, from an organizational perspective. This year was the first year that we've tried doing the amalgamated time, so not giving you a very specific amount of time for each submission. And I was wondering how it was going to go. But I think you all showed a lot of discipline and teamwork in actually sticking to those, allowing your co-counsel the adequate amount of time and not going over. I honestly did not know how it was going to go, and you've provided a really good template for us going forward, because it kind of allows you to maneuver which arguments you want to prioritize, which you want to spend a little bit more time on. So well done on that as well. Now, without any further ado, actually, with a little further ado, I should say, I just want to tell you a little bit about Gloria Epstein and the award for oral advocacy and what this kind of legacy means. Gloria Epstein graduated in 1972 from Queen's University. She earned an honors Bachelor of Commerce. She's a graduate of the University of Toronto, Faculty of Law, earning a Bachelor of Laws in 1977. She founded one of the first Toronto-based law firms that was owned by a woman. She often lectures on the role of female lawyers in Canadian law and her own experience in being raised to the bench while raising 3 children. In 1999, Epstein, then serving on the Ontario Superior Court of Justice, ruled in M&H that the definition of a spouse in the Ontario Family Law Act was unconstitutional because it discriminated against homosexual people. The ruling was upheld by the Ontario Court of Appeal and the Supreme Court of Canada after appeals by the Ontario government of Premier Mike Harris. Justice Gloria Epstein was a co-chair of OJEN's board of directors and a real champion for OJEN programs. Upon her retirement from the board, it was decided that she would be honored with an award in her name, given to the best oralist at each Charter Challenge finale. So that's a little bit about this award and why you're getting this. And I'll pass it back to our judges panel to announce the winner.
Thank you very much. Needless to say, it was very difficult for the panel to pick a winner because everyone did a great job, really. But we're required to pick a winner, and we have picked a winner. And the panel's congratulations go to Ms. Annette So. So congratulations for winning the Gloria Epstein Award.
Thank you. Thank you very much.
All right, so that concludes the formal element of today's Charter Challenge finale. Very well done to everybody for being here. Thank you very much to our judges panel for being here, and our clerks behind the scenes for helping to organize so much of this. And it really couldn't have happened any other way without you. And really thank you to our students for appearing in what looks like a teacher's lounge or something like that. We're really hoping that next year we can do this in person at the Superior Court and give an experience. But I think you've had a really unique experience, and you've really overcome a lot of barriers to be here and participate at the highest level you can in high school in terms of engaging with this kind of legal content. So again, well done. Now, before we head into our clerks panel, I don't want to put you on the spot, but if anybody had any questions for our judges about their journey in law or their experience in the field of law, it's a pretty unique opportunity to ask. So I'll just leave the floor open to you really quickly. Go ahead.
I have a question regarding like constitutional law in that field. And so it is the field that I'm most interested in, compared to a bunch of the other fields of law. But does it make sense to study law now with that in mind, with that as the end goal? Or because I know it is quite a niche field.